Thanks, Gary. So our last speaker for today is Neil Weinrich. Neil is one of my partners. We've practiced together for nearly 10 years now. Neil's truly one of the smartest lawyers I know. We decided to add this topic this year to what we had done in the last 20 years or so. Neil and I participated and spoke at a trade secret summit up in Boston back in November. And both with this federal trade secret statute that's being debated in Congress, as well as some of the developments around the country in various legislatures, we thought it would be good to talk about what's going on elsewhere, given that most of our practices involve not only litigation in Georgia, but all over the country. One of the most interesting ones for me that he'll talk about is Hawaii. In Hawaii, they implemented a ban on non-competes, but only for companies in the high-tech, in technology businesses. So Neil will talk more about it, but you know, it's one of those things from a policy perspective. You have states going in different directions, and there really is no trend that seems to be the legislatures seem to be following as to whether the covenants should be non-competes should be more strictly enforced or less. So I'll let Neil take it from here.
Thanks, Ben. As Ben kind of laid out, really have kind of a twofold agenda for my presentation. Give a status update and primer of what's going on with the these efforts to federalize trade secret law that you've gotten a preview of over the course of the day. And then the second component with the time I have left will be to do a survey of the past and proposed legislation that came up in 2015 across the country on non-compete and trade secret issues. Really, the starting point, for the federal trade secrets legislation that I want to kind of back up is how did we get there? And it kind of goes without saying based on what we've all talked about today, but the rise of information and data and trade secrets and confidential information leaving companies primarily through former employees, taking information on thumb drives, on hard drives, emailing information to themselves. Those kinds of issues have increased rapidly in the last 15 to 20 years. What that's led to is more trade secrets, lawsuits in state and in federal courts when there's other bases to get into federal court. There's another issue where attention has been brought to trade secret theft is foreign espionage, rogue nations or rogue foreign corporations taking information through hacking from United States companies, major companies trying to take information from the government, including trade secrets. And in the last few years or so, there was actually a study by Price Waterhouse and Create.org kind of jointly put together this study that attempted to do an economic analysis of what the impact on trade secret theft was on the U.S. GDP, and they pegged it at 1 to 3%, which obviously a very, very significant number. So, like I said, in the last 10 or 15 years, we really had a lot more attention on trade secrets and trade secret theft. And over time, that's led to this movement towards a federal trade secrets law. And that really started probably 10 or 15 years ago in academic scholarship, legal scholarship, law review articles, kind of proposing the idea of putting trade secrets on par with other intellectual property assets that are regulated by federal law, like patents, trademarks, and copyrights. That was kind of the starting point, and over time, as this has become a bigger and more significant issue, and as more companies are dealing with more and more litigation involving employees taking trade secret information, businesses have shown an increased interest, and industry has shown increased interest in there being a federal remedy. And all those things kind of have led to Congress catching on, and a couple of years ago, 2013 and 2014, there were there was trade secret legislation introduced in Congress. These have been, and the current proposed legislation, it's bipartisan. So there's that's rare, and that's indicative that we will likely get to the day where there is a federal trade secret statute. There has been some criticism of these proposals along the way. I think in response to either the 2013 or the 2014 proposed legislation, there were a group of law professors that joined together and wrote a letter to the members of Congress who are behind the legislation, identifying some concerns and issues, and we'll talk about some of those a little bit later. So the 2013, 2014, there was really no traction, and there was kind of some public criticism and there was just kind of the usual stagnation in Congress, so it wasn't passed in any of those sessions. And then this past year, the Defend Trade Secrets Act of 2015 was introduced in the Senate in July. Again, it's bipartisan. There's been less kind of criticism in the trade secrets intellectual property community. There's more greater support for it. Seems to have pretty good momentum. Noted here on the slide, there was a Senate Judiciary Committee hearing on it just a month or so ago. So we're not there yet, but we appear to be on the path where it's very likely that, if not this year, hopefully very soon, there will be federal trade secrets legislation. So if it passes in its current form, I kind of want to talk about what the Defend Trade Secrets Act that has been proposed looks like and what it does, so that once it is in place, all the litigators in the room know what to do with it. The Defend Trade Secrets Act, it amends the Economic Espionage Act. And for those of you who are not familiar with the Economic Espionage Act, it's a criminal law. It's focused on corporate espionage. And this bill would amend it to provide for a civil cause of action. And more specifically, the verbiage from the statutes create a civil cause of action if an owner of a trade secret is aggrieved by a misappropriation of a trade secret that is related to a product or service used in or intended for use in interstate or foreign commerce. And there's actually, I think, a couple of interesting things about that definition, or kind of what gives rise to a cause of action under this act. One touches on a point that I think Carl mentioned earlier, which is the Candy Craft case, the issue of, do you have to be an owner of a trade secret to have standing to pursue the claim? And if you read the federal statute, whereas the Candy Craft case, I think, found that was not necessarily required per se, that you have to be an owner under the Georgia statute to have standing. The federal trade secret statute, it looks clear that that's the case. The other interesting thing about the definition is causes of action for theft of a product or service that is used in interstate commerce. Begs the question of if it's a purely intrastate dispute, which I'm not sure that there are purely intrastate disputes these days, but if there is one, if it's a case that involves a Georgia company, Georgia employee, and Georgia employee goes to a Georgia competitor, and all the customers at issue are all in Georgia, there may be a question about whether there is a cause of action under the new federal law. The Defend Trade Secrets Act is generally modeled after the Uniform Trade Secrets Act, which the Uniform Trade Secrets Act has been adopted in some way, shape, or form, and I believe the number now is 48 of the states. Some of the definitions that you see in the DTSA mirror the UTSA's definition. I think that definition is a trade secret, definition of misappropriation. Similar remedies that you'll find in the Uniform Trade Secret Act, injunctions, damages for actual loss, unjust enrichment damages, royalty damages, exemplary damages, and attorney's fees. One interesting aspect of the law is it will not preempt state trade secrets laws. I'll talk about that in a little bit, but that will potentially create a interesting dynamic in trade secrets litigation. And there's a 5-year statute of limitation under the DTSA. Different states that have adopted the Uniform Trade Secrets Act have, I think it's anywhere from a 2 to 5 year statute. So there's variation in state law on that. The provision in the Defend Trade Secrets Act that gets the most attention has been the Ex Parte Seizure provision. Under the Defend Trade Secrets Act, a court would be empowered upon an ex parte application to order the seizure of property that's necessary to prevent the propagation or dissemination of the trade secret that is the subject matter of the action. That is this express ex parte seizure provision that's part of this law would obviously be a potentially pretty powerful tool for companies and employers who have been a victim of trade secret misappropriation to run into federal court and get their trade secrets back. Let's talk a little bit about how the the ex parte seizure provision works. The requirements to obtain an ex parte seizure order, the statute says a temporary restraining, there has to be a showing that a TRO under Rule 65B would be inadequate to prevent disclosure and that immediate and irreparable injury will occur without seizure. An ex parte seizure order, it has to be based on findings of specific fact. Court would also be required to find that the harm to the moving party, if a seizure is not ordered, would outweigh the harm to the legitimate interests of the party against whom the seizure would be ordered and substantially outweighs the harm to any third parties. I think that last part is interesting because it appears that they're contemplating that there are ancillary effects to a seizure provision, potentially, if the defendant misappropriates trade secrets and is using those trade secrets or using those trade secrets in conjunction with other information to provide products or services to customers, that's a effect on a third party that seizure is going to have a significant impact on. The applicant for the seizure has to make a showing. They have to be likely to succeed in showing that the information in question is a trade secret, was misappropriated by the other party, and that the other party has possession of the trade secret. Those are kind of go without saying. What I think is pretty interesting to consider in those factors is typically that TRO hearing where a contested TRO hearing where the defendant is disputing that he or she took trade secrets and that the information that was taken is actually a trade secret. That oftentimes in these kinds of cases, there's a very huge battle at the TRO stage over whether the information at issue is truly proprietary, whether the company truly took the necessary steps to treat the information or data as a trade secret, and essentially whether the information taken meets the criteria for constituting a trade secret. Under this regime, this is ex parte, so the defendant is not getting the opportunity to make the arguments and present the evidence that would typically be presented at a TRO stage, and the court will be making a determination that the information in question is likely a trade secret without the benefit of any of the defendant's evidence. There are protections that will address that, and we'll kind of get to that in a second. Other requirements for obtaining the ex parte relief, the applicant has to have not publicized the requested seizure. I've kind of got this misworded on the slide. I was looking at the statute earlier, but it's essentially that the filing of the request for relief, it appears that has to be the first publication of the request. The applicant has to describe with reasonable particularity what must be seized to protect the trade secret, including where it's located. And then finally, the applicant has to show that the party against whom the seizure is sought would seek to destroy, move, hide, or otherwise make such matter inaccessible without seizure. And kind of who knows if this legislation is passed, what exactly the practice is going to be like in federal court on ex parte seizure provisions. But if I had to take a stab, I really think that that provision right there might be the kind of the linchpin of when ex parte seizure orders are appropriate. I think judges tend to be pretty hesitant to entertain ex parte relief, but if there's a demonstration that the defendant is going to destroy evidence, I think that's the scenario where courts believe that can be persuaded that that ex parte seizure might be appropriate relief. Kind of diving into some more of the procedural issues, what is an order that granting an ex parte seizure, what does the order have to look like? Mentioned earlier, court has to make specific findings of fact and conclusions of law, showing why the issuance of the order is required. Order also has to be narrowly tailored as possible to protect the trade secret while not interfering with the legitimate business interests of the party that's accused of misappropriating the trade secret. Another requirement, any material seized, they'll be taken into custody of the court. No copies or disclosure will be made. What happens after a seizure has taken place? Court has to hold a hearing not later than 7 days after the order is issued, unless the defendant consents to a hearing at a later date. At this 7-day hearing, the movement has to establish that the findings of fact that were initially made to support the order, as well as the conclusions of law that were made, those continue in effect. They have to essentially kind of carry that burden again with the defendant there to contest them. A party who has had information seized can also move for a modification or dissolution of the seizure order at any time. If they suffer damages due to a overly broad seizure or wrongful seizure, under the statute, they would be entitled to relief from the moving party. And there's a bond requirement. So that's kind of the rundown of how the statute works. I alluded to earlier, there's been, on the whole, positive reaction, but it's been mixed reaction, and I just want to kind of briefly run through, what are the concerns, kind of the pros and cons that people have been talking about. The primary negativity has been the concern about abuse of the ex parte seizure provision. I think I mentioned there were professors who sent a letter regarding a prior version of the proposed legislation that included the ex parte seizure provision, and they raised the concern that the ex parte seizure provision was ripe for abuse and used to stifle competition as opposed to for genuine use to recover misappropriated trade secrets. I think the reaction among practitioners, and I agree with it, is that there's reasonable protections in place in the current version of the statute to eliminate abuse. And I think the other thing here is, federal judges. I would be very surprised if when this law hopefully goes into effect, if it's too frequent that federal judges find that extensive ex parte relief is appropriate. I think that even though the statute allows ex parte relief, it is probably going to be reserved for those most egregious situations. The people defending the provision have pointed out that there's a similar provision in the Lanham Act that where ex parte seizure orders for counterfeit marks are permitted. And I think most folks out there practicing in this arena and many business people that have, particularly those that have been the victim of trade secret theft, believe with good reason that the ex parte seizure provision is necessary in certain instances to recover stolen trade secrets. There is a debate about uniformity, and some of the support for the Defend Trade Secrets Act is based on the idea that having a Federal Trade Secrets Act and a body of case law that develops around that Federal Trade Secrets Act will have the effect of creating some uniformity in trade secrets law around the country. I mentioned earlier that right now you've got different states that have adopted the Uniform Trade Secrets Act, but many states have made modifications to the Uniform Trade Secrets Act, and even where states have adopted identical versions of provisions in the Uniform Trade Secrets Act, they've been interpreted entirely differently from state to state. The best example of that is the preemption provision. Carl talked earlier about how there's some cases in Georgia where preemption is viewed pretty broadly. There's cases in other states where trade secret preemption is much more narrowly construed. The flip side to whether the Defend Trade Secrets Act will have the effect of creating uniform trade secrets laws is the Trade Secret Act itself doesn't preempt state trade secrets laws. So I think we're going to end up in a situation where if a year from now this passes and a client comes to me and wants to pursue a claim against a former employee that took information, I think I'll be able to tell the client, well, you have a cause of action under federal law, and we can also bring a cause of action under Georgia state law, and those are two cause of actions that you can bring. And it's obviously conceivable that there's hurdles or problems with one of the laws or one of the cause of action under one law, and there's whereas the other law provides a stronger cause of action. So no one knows exactly kind of how that's going to play out, but I do think the uniformity argument for the Defend Trade Secrets Act is it's a mixed bag. Another criticism or concern that's been raised about the Defend Trade Secrets Act and federal trade secrets legislation is the possibility of the emergence of trade secret trolls similar to patent trolls. They're trade secrets cases. They've been around for quite some time. Most everyone knows that. Everyone here on the panel certainly knows that, and there really haven't been any signs of trade secret trolls emerging, and I personally don't think that there is any reason to expect that the passage of a federal law would lead to trade secret trolls the way there are patent trolls for non-practicing entities. So the bottom line on the Defend Trade Secrets Act, trade secret theft these days is a very important issue for companies, big, small, and medium. And I do think the Defend Trade Secrets Act or passage of similar federal legislation would help companies out there protect their intellectual property. So that's part one of my presentation. And with the few minutes that I have left, I'm going to run through some of the developments in non-compete and trade secret laws from last year from other states. Do what I can in the time I have left. Tom kind of briefly hinted at the change in Alabama law, and I'll kind of run through that in a little bit more detail. Alabama revised their Section 8-1-1. There's still a general ban on contracts in restraint of trade, but there's the exceptions which are enumerated on this slide. I won't read through them. They're also in the paper that you have under the revised Alabama law, an employer does have to show that there's a protectable interest, the type of protectable interest, trade secrets, confidential information, customer, patient, vendor, or client relationships and goodwill, specialized or unique training. The statute expressly says that general job skills are not a valid protectable interest. I thought that was pretty interesting. Alabama, the new law has some presumptively reasonable timeframes for restrictive covenants. It's 2 years for a non-compete, 18 months for a customer non-solicit, 1 year for non-competes in the sale of a business. And I've been kind of racking my brain to figure out why you would have a 1 year presumption for a sale of business that would be less than 2 years for an employee non-compete, and why you would have a situation where you can, after 18 months, a employee would be allowed to solicit customers but not necessarily compete because a 2 year non-compete is permitted. I haven't figured that one out, but state Alabama. And the new law in Alabama, it allows for judicial blue penciling of overbroad non-competes. New law in Arkansas allows non-competes as part of an employment agreement, as long as the employer has a protectable business interest and the agreement is limited in time and scope. The protectable business interests that are permitted under the statute, those are up there in the slide. Interestingly, Arkansas, the new law there does not require a geographic limitation in a non-compete, as long as the non-compete is limited in time and scope. Presumption that 2 years is reasonable. The law allows Arkansas courts to reform overbroad covenants, which previously that was not allowed. Ben mentioned Hawaii. Hawaii is probably the most interesting legislative development, in my opinion, from this past year. Hawaii, the new Hawaii law bans non-competes in technology businesses, also bans employee non-solicitation covenants. And really the goal of this law, the bill itself, it talks about how the unique geography of Hawaii, I'll actually just read the language from the bill. It says because the geographic nature of Hawaii is unique and limited, non-compete agreements unduly restrict future employment opportunities for technology workers and have a chilling effect on the creation of new technology businesses within the state. It seems that the technology businesses in Hawaii were having to look to the mainland to attract new talent because they couldn't hire employees from other technology businesses in Hawaii because apparently non-competes were being enforced. The statute defines what a technology business is. It's a business that derives the majority of its sales from software or information technology department. The net of the statute is that reasonable non-competes for employees who are not working in a technology business are permitted. There was a proposed bill in Michigan. It's pretty interesting because I think it was a direct or close to direct reaction to the Jimmy John's scandal. For those of you who follow non-competes, you probably heard about what Jimmy John's did in the last year or so. For those of you who don't, Jimmy John's tried to have all its workers sign non-competes which prohibited the employees from going to work for any, it wasn't just a sandwich location, it was any restaurant that derived, I think it was 10% of its sales or more from the sale of sandwiches within a 3-mile radius of any Jimmy John's in the country. And the way the covenant read, it would have applied to the guy or girl behind the counter that's asking you how much mayo you want on your roast beef sandwich. And there was It was picked up on in the media. There was some negative coverage and some it kind of drove a period of animosity toward non-competes, and the bill that was proposed in Michigan would have been a complete ban on non-competes except in connection with the sale of a business. New Mexico, real quick, the law in New Mexico, it makes non-competes unenforceable for certain groups of healthcare practitioners. The slide is actually slightly off. The way the law works, the issue of kind of the first 3 years of employment, how that fits in. The law provides that an employer, it can have a non-compete with healthcare professionals, but it can build into the agreement that if the healthcare practitioner leaves within 3 years of joining the company, they can be required to, if they were paid moving expenses or the like, the agreement can provide that those monies be reimbursed. So can't have a non-compete, but can make them pay back some relocation costs. Non-competes would still be allowed if the medical professional is a shareholder, an owner, a partner, or a director of the healthcare practice. New York had proposed legislation. The purpose of the proposed legislation in New York was kind of the stated reason was there was a case. It was actually a 99 case, so the case had been out there for some time, but I think some other case law had developed around it that may have led to increased enforcement of non-competes in New York, and the proposed legislation was intended to kind of reassert that non-competes are disfavored in New York, particularly making clear that lower-level employees and independent contractors cannot be subject to non-competes. There's a new law in Oregon. The new law in Oregon, it shortens the permissible duration of employee non-competes from 2 years to a maximum term of 18 months. One particularly interesting thing about the Oregon law, and I'm a bit surprised that I haven't seen this in other states, is there's essentially a salary cap. So for an employee to be subject to a non-compete, the employee's annual gross salary and commissions at the time of termination must exceed the median family income for a family of 4, but a non-compete can be enforced even if the compensation level is not met, if the employer pays the former employee 50% of the employee's salary for the duration of the restriction. Essentially, it's a garden leave provision for the full term of the non-compete, or half garden leave. There were several different bills introduced in Washington. Several different subject matters. One dealt with physician non-competes and would have made physician non-competes unenforceable. Another was a proposed kind of general ban like California. Another proposal was a more moderate approach that would have permitted reformation of non-competes in Washington. Kind of shows there was not necessarily a consistent direction in what folks in Washington were interested in doing as far as non-competes, moves in several different directions. Wisconsin, and Wisconsin's the last one that I'm going to run through. A legislation was introduced in Wisconsin that would have strengthened the enforceability of non-competes. There had also been some case law in 2014 that strengthened non-competes in Wisconsin. That case made made it clear that continued employment was sufficient consideration for a non-compete in Wisconsin. I think that had been unclear before that. One aspect of the Washington bill, the bill would provide that in evaluating a restrictive covenant, the courts were instructed to consider the length and nature of the employment relationship, potential harm to the employer's business interests, relevant conduct of the former employee, and the standards of the industry. Those tend to be, all those issues tend to rise to the forefront in these kinds of cases, regardless of whether it's statutorily provided. I just thought that was pretty interesting that was expressly included in Wisconsin's proposed legislation. Just a couple other small notes as I was kind of reviewing the other few pieces of legislation that are included in the materials. Minnesota, they had proposed legislation, but didn't move forward. But I think another proposal that was put in place, and I think this was passed. I'm not 100% sure about that, but there was a legislation that provided for a study to study of the impact of non-competes on low-income workers. I think that was interesting that Ben kind of touched on what was done in Georgia prior to the enactment of the new law. I think I view that as a right move for the state of Minnesota to kind of do some studies to undertake to figure out kind of what are what's the impact of non-competes in the state. That one was less focused on what's the impact of non-competes on attracting new business or retaining business to the state, but I would assume that a study of that nature would probably hit on that as well. And then Pennsylvania, similar to I think a bill that was introduced in Washington, there was a bill introduced there to ban physician non-competes in their entirety. There's states out there that have taken that approach with respect to physician non-competes. So that's kind of a rundown of the state law developments in non-compete and trade secrets in 2015. I think it's pretty interesting to see what different states are doing. I think there's not really a trend. The trend is that I think a lot of people are paying attention to non-competes, but there's pretty divergent approaches on whether states are favoring enforcement or whether states are moving towards protecting employees from non-competes. I think it's beneficial for us, particularly those of us who represent companies, to have an understanding when we're advising our clients that have employees in multiple offices and in multiple states, what some of the laws are in other jurisdictions, as that can drive where you put people and what you do with people that you hire from competitors that are subject to non-competes. Thank you.
Thanks, Neil.